Thank you. Thank you, everyone, for attending our press conference today to speak to Bill 57 and specifically to Schedule 15 of Bill 57, which deals with changes to the Environmental Commissioner of Ontario's office and to the Environmental Bill of Rights. Here with me today is Ellen Schwartzel, retired Deputy of the Environmental Commissioner of Ontario's office, and Richard Lindgren, Counsel with the Canadian Environmental Law Association, and myself, Teresa McClanahan, Executive Director with the Canadian Environmental Law Association. Later this afternoon, Richard and I will be presenting to the Standing Committee on Finance and Economic Affairs regarding Schedule 15 to the bill about our serious concerns with respect to the Commissioner's office and the provisions in that bill. We'll be presenting on behalf of three organizations at that time: Ontario Nature, which has 30,000 members and 150 member organizations, and works on protecting wild species and wild spaces, as well as on behalf of the Friends of Porcupine River Watershed, a nonprofit organization from Timmins who are dedicated to protecting the Porcupine River and Lake watershed. The Canadian Environmental Law Association, our organization, is a nonprofit public interest organization established in 1970. And as a legal aid specialty clinic, we're also especially focused on low-income and vulnerable community issues and using environmental tools to protect environmental health and the environment. I'll just quickly speak to one example of the importance of the Environmental Commissioner's Office, which is one highlighted by the Friends of the Porcupine River Watershed, who have been struggling with raw water sewer discharges into Porcupine Lake for some time. Because of this struggle, they eventually reached out to the Environmental Commissioner's Office, who provided assistance with presenting a request for investigation to the Ministry of the Environment and Climate Change, and subsequently that investigation was conducted and an order was issued. In her most recent report, the Environmental Commissioner of Ontario said that the Ministry's investigation confirmed that the applicants, that is the citizens in South Porcupine, are correct and the city is breaking the law. Its deteriorating sewage system causes sewage to bypass treatment and discharge directly into Porcupine Lake. So that example, along with many others in her report, supported one of the Environmental Commissioner's findings this year, that the ministry tolerates combined sewer overflows from municipalities without requiring them to exercise due diligence and comply with the relevant legislation, the Ontario Water Resources Act. So the Friends of Porcupine Lake were therefore very dismayed when 2 days after that report was introduced in the legislature, there was the introduction by way of Schedule 15 to Bill 57, a proposal to remove the independence of the Environmental Commissioner of Ontario. And they reached out to us, asking us to speak on their behalf this afternoon at committee, as did Ontario Nature as well. We've also provided letters that have been signed by over 4,000 individuals and organizations sent to the Premier about requesting that Schedule 15 be deleted and stressing the importance of the Commissioner's office. And in addition, Ontario Nature themselves circulated to their members and obtained individual endorsements from another 4,012 Ontarians asking for Schedule 15 to be deleted as well. So I'll turn it over to Richard Lindgren to speak to some of the substantive concerns with the bill.
Great. Thank you, Teresa. As she indicated at the outset, I'm a staff lawyer at the Canadian Environmental Law Association, and I start from the proposition that if something is not broken, don't try to fix it. And in my view, the Environmental Commissioner is not broken. To the contrary, the Office of the Environmental Commissioner has served the people of Ontario exceptionally well over the years, both as an independent environmental watchdog and as a strong advocate and a strong guardian of the Environmental Bill of Rights, or EBR in short. And therefore, it's our view that the Ontario government should not try to fix the Environmental Commissioner by abolishing that office. A number of years ago, I was appointed to the Environment Minister's Task Force on the Environmental Bill of Rights, and that essentially was an advisory committee consisting of representatives from industry, from government, and from the environmental sector. And in short, we helped write and consult on the Environmental Bill of Rights, including the provisions that establish and empower the Environmental Commissioner of Ontario. At that time, Ontario already had the Auditor General, and that office was focused and still is focused on ensuring financial accountability in this province. But the task force decided and unanimously agreed that the province of Ontario should take extra legislative steps to ensure meaningful environmental accountability in this province. And that's why we established the Office of the Environmental Commissioner. We made the Environmental Commissioner an independent officer of the legislature, not the party in power. And we gave the Environmental Commissioner a long list of specific monitoring, reporting, and public education duties under this new law. And the EBR, with these important provisions, was passed by Ontario in 1993 with all party support. And in my view, over the past 2 decades, the Environmental Commissioner's Office has met or exceeded the expectations of the task force, as well as the clear legal requirements of the Environmental Bill of Rights itself in terms of ensuring government accountability for environmental decision-making. However, as my colleague has indicated, the Ontario government has recently introduced Bill 57, and Bill 57 contains a schedule, namely Schedule 15, which proposes to abolish the Environmental Commissioner of Ontario. And in response to that proposal, CELA has prepared a very detailed legal analysis. Copies of that are over at the media table if anybody wants to take a copy. And I'll be presenting that legal analysis to the Standing Committee later this afternoon when I appear as a witness on the Bill 57 matter. CELA's overall conclusion is that the government's proposal to abolish the Environmental Commissioner's Office is an unjustified rollback of existing legal requirements that will result in far less transparency, far less oversight, far less accountability for environmental decision-making in Ontario. And let me conclude by offering 3 brief examples of how Bill 57 changes the Environmental Bill of Rights, but not for the better. Number 1, while the EBR establishes the Environmental Commissioner as an independent officer of the legislature, Bill 57 will make the new commissioner a mere employee of the Auditor General, and that employee is subject to the direction of the Auditor General and not the Ontario legislature. Number 2, while the EBR contains prescriptive details in terms of the Environmental Commissioner's current functions and duties, most of those details are absent from Schedule 15 of Bill 57, which creates considerable uncertainty and leaves the new employee with virtually no legislated tasks under the new bill. And then finally, number 3, while the EBR empowers the Environmental Commissioner to issue periodic special reports on the most pressing environmental problems of the day, Schedule 15 does not empower the new employee to issue any special environmental reports at all. And so for these and other reasons, CELA is calling upon the Ontario government to withdraw Schedule 15 of Bill 57. In our view, the Office of the Environmental Commissioner must be maintained in its current form under the Environmental Bill of Rights. And with that, I'd pass things over to my colleague, Ellen Schwartzel.
Thanks very much, Richard and Teresa. Good afternoon. My name is Ellen Schwartzel. I was Deputy Environmental Commissioner from 2013 to the summer of 2018, and I'm now retired. But I served 3 environmental commissioners stretching back to 1995, so I have 24 years of experience with the office, including testifying at Walkerton. I want to share my own observations on how the office adds value to Ontarians, real service that's about to be lost, services that will not be provided under the Auditor General. Under Bill 57, we are losing our standalone environmental voice at Queen's Park. Right now, the Environmental Commissioner can talk directly to the legislature, the MPPs, and the media. When the commissioner releases an annual report, he or she can explain the background to the public through talks, tours, webinars, and media interviews. The commissioner also has discretion to issue special reports and has issued about 8 in the last decade. Those reports can provide valuable early warnings. All of those services will end under Bill 57. A mere employee of the Auditor General will not have discretion to speak directly to MPPs or the public. They won't have the discretion to issue special reports. In effect, we're disabling fire alarms, and we know what can happen when we disable fire alarms. It's a bad idea. Ontarians are also losing the right to trigger reviews under the Environmental Bill of Rights for stronger laws and policies. At first blush, some might think, oh, that right is still there, but it's there in name only. People can still ask, but the ministries will no longer be held to account by the Commissioner for how they respond to review requests. The Commissioner's regular public reporting on this, and yes, badgering, was vital to give that particular tool legitimacy. And make no mistake, the Ontario public used this right to very positive effect. To name just a few examples, the Citizens Tool played a big role in the protection of the Oak Ridges moraine, a strengthened Provincial Parks Act in 2006, stronger rehabilitation rules for sand and gravel pits, and recently it gave some help to rural communities that were beleaguered by unwanted dumps of excavation fill. We are also losing the site-specific focus, especially in rural and northern Ontario. Environmental problems often show up as local hotspots, and they can fester unresolved for years. Noise and dust from gravel pits, fly ash from aging cement plants, landfill seeps, groundwater problems. MPPs really struggle to deal with them in their ridings. MPPs can find it very difficult to get ministry staff to come and speak to groups of unhappy citizens. But the Environmental Commissioner can come and be an active listener. Indeed, several MPPs, 3 of them now cabinet ministers, had the Commissioner in their ridings over the last 2 years. The ECO can explain the technical and regulatory issues and the tools available to the public. That honest broker presence of the Commissioner can help advance issues that have stalled, and that's worth gold. But community visits and honest broker listening are not tools of auditors general. Last, but very importantly, we are losing the independence of our expert voices at Queen's Park. Because keep in mind, Bill 57 would not just silence 3 watchdogs. It would undercut the independence of every legislative officer, from the Auditor General to the Clerk, the Ombudsman to the Integrity Commissioner, by threatening them with suspension at any moment. This is most alarming. The job of legislative officers is hard by definition, to tell uncomfortable truths to government. Who will tell uncomfortable truths in the face of constant fear of losing their jobs? They could be suspended on the mere opinion of government, and with no recourse or compensation, as Bill 57 makes clear. The job of MPPs is also hard, with complex files and a punishing pace. They rely on Ontario's legislative officers to support their work with expert, unvarnished perspectives. So what's being attacked here also is the ability of MPPs to access uncomfortable truths and to serve constituents with the best decisions. Thanks for your time, and we welcome your questions.
Are there any issues in the past that you can speak to specifically that have benefited from the existence of the ECO that may not have been resolved if that office didn't exist at all?
There are quite a number. It's 25 years of experience, and this afternoon I also have 5 minutes to speak to those 25 years of experience at the Standing Committee. And I'm going to point out, for example, in the Picton area, there's an aging cement plant. And residents there had to deal with, for decades, with really problematic ash emissions. And they called it, sometimes it was as though a volcano had erupted. And they finally were so frustrated that they used the Environmental Bill of Rights in 2011 to ask for action. And the Environmental Commissioner highlighted that issue to the legislature. And then in the fullness of time, there were charges laid, and the company was fined $350,000 plus a victim fine surcharge. So there's just one sort of in a nutshell little example, but there are many. And many of them are smaller, they're local issues, but they are enormously important quality of life issues for people, especially in rural Ontario. If your groundwater is contaminated, or you find that your neighborhood has fumes wafting over it, who are you going to call? That's really the question.
The mandate is being transferred to the Attorney General, which is more of a value for money kind of accountability. Do you think that suggests something about a different approach to environmental issues, looking at it more from like a business or financial kind of aspect? Is there any concern?
Yes, so some of the tasks are being transferred to the Auditor General's office. And yes, the Auditor General does have a value for money mandate. The focus is to look at the financial affairs of the province. And of course we need that as a taxpayer. I want the Auditor General to do that. But I also think that with a very sophisticated economy here, a 21st century economy that is still very largely resource-based, we have multiple billion-dollar resource-based industries. We need somebody directly at Queen's Park who can speak without fear or favor for the trees.
If I could add to that, and this loops back to the first question, I've been involved in a number of cases over the years where the Environmental Commissioner has intervened. The Environmental Commissioner has come to the local community and spoke to the folks and got a good sense of what the issues are and what the concerns are. And in at least a couple of instances, I've been involved in court cases where the Environmental Commissioner intervened as a friend of the court to help the court come to the correct interpretation of the Environmental Bill of Rights. I'm not sure the Auditor General goes to bat for community groups like that, and that's why it'll be a profound loss if that ability no longer exists in Ontario.
We're also kind of at a crossroads in terms of policy on environment. There's big changes being made to how the province deals with issues like climate change. Do you think that the timing of removing this office is also kind of problematic in light of that?
Yes, I'd say so in that when we saw the climate plan announced on Thursday last week, there were quite a few things included in that plan that are in the nature of things that the government hopes to work on and hopes to provide more detail and more action on in the future. And so down the road, an independent environmental commissioner would go back to that plan, look at what the government had said they were going to do, ask for evidence about whether they did those things, and report to the legislature and the public about those things. And that was a responsibility that was frequently exercised, and specifically on that topic of climate change and energy conservation is another one. The current commissioner has been given statutory mandates to provide special reports to the legislature every year on those topics, and those special reports are now being eliminated. So one of the biggest issues of the day, climate change, is now something that isn't being singled out for that spotlight, and that was critical, and we would advance remains critical function of the office.
How would you respond to the argument that this is how it works on the federal level? Why does Ontario need an independent environmental commissioner's office?
Well, I've certainly heard that argument, and I've actually gone and looked at the Federal Auditor General's Act, and it doesn't compare at all to Schedule 15. So, for example, the Federal Environmental Commissioner is appointed for 7-year terms. We don't know what the term is going to be for this new Commissioner of the Environment. As well, the Federal Environmental Commissioner has a long list of statutory duties and responsibilities, which look pretty much like what the Environmental Commissioner does here in Ontario. And again, those details are conspicuously absent from Schedule 15. So if you're to ask me, well, what exactly is this new Commissioner going to do? I can't answer because those duties aren't spelled out in the bill like they are under federal law.
Might I also respond to your question, why federal versus provincial? And let's keep in mind that in a federation like Canada, much of the environmental responsibility has been delegated to the provinces. So really, the provinces do the heavy lifting on the environment. If it comes to setting out the rules for sand and gravel pits, or who gets to take groundwater in your neighborhood, or who's responsible for Lake Ontario shorelines, mineral extraction, furry animals, scaly animals. It's all at the provincial level. And Ontario is a very big province, as I said, very big resource industries. And yes, we need that presence at Queen's Park to make sure, and it's worked really well for the past 25 years.
Okay, thank you very much.
Great,
And
thank you.
thanks
Thank you.
everyone for coming. And if there are any further questions, we've put our contact information on the material that we left with you. All right, thank you.
Great, thank you.